Good morning.
Good morning, Chair and Commissioners. Today we have Advocate Ledwaba, who is going to be giving his evidence, and my learned colleague Nalani will be dealing with that aspect of his evidence.
Thank you.
Good morning. He's actually Mr. Ledwaba, not advocate. Just slight correction, but that will become apparent later.
It's Mr. Ledwaba.
Mr. Ledwaba.
Yes. Mr. Ledwaba, are you going to give your evidence under oath or affirmation?
Under oath, Chairperson.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Mr. Ledwaba, you have a bundle before you which has a statement or affidavit that you deposed to. You have that?
I confirm.
The affidavit appears from page 1696, paginated. Confirm that?
I confirm that.
If you turn to page 1722, there is a signature that appears there.
I see it, Chairperson.
Whose signature is that?
It's mine.
Do you therefore confirm the contents of this affidavit?
I do.
And you stand by the contents?
I do, correct.
Before we start with the contents of the affidavit or statement, do you have any corrections to make the statement?
Correct, Chairperson. We have few corrections.
Yes. At paragraph 1,
In paragraph 1, the word Hamashashani is missing one alphabet. It's A after the H to read Hamashashani.
so you should read G-A-M-A-S-H-A-S-H-A-N-E.
Correct.
And then if you turn to paragraph 6,
Sorry,
page-
5.2.
5.2, any correction there?
In the second sentence under 5.2, it's typed Directorate of Special Investigations. That investigation is incorrect. Should be replaced with the word operations. Directorate of Special Operations.
DSO.
DSO.
The next correction?
The next correction is in paragraph 6, first sentence. The degree of Buris says University of the North. The North is incorrect, should be South Africa, UNISA.
So you should read University of South Africa.
Indeed, correct.
Next correction that you want to make?
In paragraph 7,
Paragraph 7.
fourth sentence or fourth line, involved in the administration of estates, we're adding the word deceased estates.
Deceased estates.
Correct.
Thank you. The next. Not on page 1709, paragraph 49.
1709.
Yes, paragraph 49.
We missed paragraph 39.
Okay, 39.
Yes.
Okay, let's go there.
Paragraph 39 starts with the word special, which is incorrect, should read specified.
Thank you. The next one.
Paragraph 49, indeed.
Yes. How do you want to correct that?
Second last sentence. Therefore, TRC cases, if only two matters, the word McCarthy there should be replaced by Nuka, Advocate Nuka.
Thank you. Yes, next one.
Paragraph 56.
56.
Last sentence, transferring the two researchers, we adding the word two TRC researchers.
Thank you.
Paragraph 66.
Yes.
First word there should be replaced with the word there.
Thank you. Next.
Paragraph 89. Fourth sentence, end of that fourth sentence, it reads currently DSO authorized projects in the PCLU. The word PCLU should be substituted with SNPU.
SNPU.
Correct.
Thank you.
Sorry, Mr. Nalani, I missed that paragraph.
Paragraph 89,
89, thank you.
the fourth line, starting with complex DSO authorized projects in the PCLU. That word PCLU substituted with SNPU.
Thank you.
Thank you, Commissioner. I think that's it.
That's it. Thank you. It is common cause that you have been served with a Rule 33 notice, correct?
Correct.
And you have been asked to come and help this commission by giving information within your knowledge, which can help the commission to look at the terms of reference.
Correct.
You are aware of the terms of reference?
I am aware.
In summary, the commission is asked to investigate and establish whether there were any attempts to interfere with or stop the investigation and prosecution of TRC cases by the South African Police Service or the National Prosecuting Authority.
I confirm that.
Correct. Now, we want to deal firstly with your identity, your person, your experience and background. That will be at paragraph 6 of your affidavit, page 1698. Are you there?
I confirm that.
Yes. But before then, in paragraph 5, you just provide a structure of your affidavit, what topics you want to cover, which will be apparent as and when you go along.
I confirm that, Chairperson.
Yes, let's start with your educational professional background. And this is covered from page 6, from paragraph 6 to 19. If you can just summarize your background. If you need to read any portion of your affidavit, please feel free to do that.
I think it will be easier if I just read.
Go ahead.
Thank you.
Yes, and if you want to explain or expand further, you can do that.
Thank you very much.
Thank you.
Paragraph 6 says, I hold a B.Juris degree from the University of UNISA, which I obtained in 1989, an LLB degree from the University of the North, obtained in 1992. I also hold an LLB degree in law of contract from the University of Pretoria, obtained in 1997, and a master's in business leadership degree obtained in 2003 from the University of South Africa.
And in paragraph 7, you deal with your work history, beginning with your time in the Department of Justice as a clerk, the Department of Justice of the then homeland of Leboa, correct?
Correct.
Yes, go ahead and deal with that.
I can summarize to say I joined the department in 1985 as an administration clerk, and the Department of Justice then was an all-inclusive department running finance, home affairs. Almost all the departments were all-inclusive in the department, which allowed me to be involved in a number of divisions at that office: administration of deceased estates, maintenance, claims, registration and licensing of cars, learners and drivers license, payment of the Leboa government tax, registration of birth and death certificate, issuing of passports, IDs and traveling documents, and even including administration of the UIF, Unemployment Insurance Fund. From 87, I was then became a clerk of the court and court interpreter, and I also had a year stint as a sheriff of the court, which was then called messenger of the court. After graduating with the first degree LLB Juris, I was appointed as a prosecutor at the Leboa Home Magistrate Court, later transferred to Magistrate Mankweng in 1991. The main aim was to complete my LLB degree in the University of the North, which I then did and completed in 1992 and remained stationed at the Mankweng Magistrate Court. 1993, I was transferred and promoted to Regional Court Prosecutor in Polokwane Regional Court, then Petersburg. And it reads in paragraph 11 that I was the first black prosecutor in the regional court then. I remained there until December 1994. I was admitted as an advocate of the High Court in October 1994, Pretoria 1994. In 1995, I was appointed as a junior state advocate within the then Attorney General's office in Pretoria, which is now called Director of Public Prosecution. In 1997, I was promoted to next rank, being Senior State Advocate at the same office, and in 2000 promoted again to be a Deputy Director of Public Prosecution, still in Pretoria, reporting to the then Attorney General, Dr. De Oliveira.
So if with 14, it's common cause that the Attorney General's office was converted when the National Prosecuting Authority was passed in 1998.
Correct.
Okay.
Prior to 98, there were, I can call them provincial attorney generals. I think there were 5 then. And after the promulgation of the Act 32 of 1998, that rank or position was abolished and replaced by Director of Public Prosecution, which were then headed by National Director of Public Prosecution, who was then Mr. Bulelane Ncuka.
And then in 15?
In 2001, I was then transferred to the Directorate of Special Operation, which is colloquially known as the DSO and or the Scorpions. I retained my position and rank as a Deputy Director of Public Prosecution, and I joined Advocate Son and Advocate McCarthy at the DSO. The two, as the heads of the DSO, were reporting to Mr. Ncuka as the NDPP. On my arrival, paragraph 16, I was assigned to lead the head of the Organized Crime Desk, a position I occupied until February 2003, because on 1 March 2003, I was appointed as an investigative director, which was referred also as the head of operation and also deputy head of the DSO, second in charge. Advocate McCarthy was then promoted to be the head of the DSO after Advocate Son left the DSO. I occupied this position until my resignation in December 2004.
Then 17, you deal with your further progression in your career?
In 2005, after leaving the NPA shortly, I began serving my pupillage at the Johannesburg Society of Advocates, GSA, and towards the end of January 2005, Advocate Piccoli invited me to withdraw my resignation that I had just submitted, and I agreed.
What was Advocate Piccoli's position at the time?
He replaced, after Mr. Nguga resigned in 2004, I think Advocate Ramaite acted for some while, and Mr. Pikoli was formally appointed by the President as the National Director in end of January 2005. After he asked me, I agreed, and I rejoined the DSO in February 2005, occupying the same position as the investigating director in the DSO, a position I occupied until I finally resigned on 30 June 2005, after which period I rejoined the JSA and continued with my pupillage program. I did my pupillage at the Duma Nokwe group, and after completion I was to join them. However, I need to add here, it is not contained in the statement, Chairperson and Commissioners. Immediately on passing the examination, I was arrested on the 13th of October 2006 from allegation arising from my then position in the DSO. The trial started in 2008 and only completed in 2018. There were a number of charges. Some were withdrawn, some were I was acquitted in terms of 174, and I was convicted on 6 counts. Prior to, I was convicted on the 5th of February 2014. Under paragraph 19, I highlight that I was struck off the roll of advocate in October 2014 because of that conviction, but prior to my sentence. I was only sentenced in July 2015, and in 19 we add that I was subsequently acquitted of all the charges by the High Court on an appeal, where the 2 judges even making serious adverse criticism against the prosecutors who handled my trial, and expressly finding that the facts never established a commission of any offense.
And currently, what are you doing?
I'm currently self-employed. Chairperson, I see we had typed and we forgot to amend it when we did the correction.
So it must read, I'm currently
Self-employed, correct.
The next topic we deal with is the structure of the National Prosecuting Authority and Directorate of Special Operations from paragraph 21 onwards. Before we delve into the detail, do you want to explain why you want to deal with the structure of the NPA at the time when you employ? Why is it important?
I think it's to assist the Commission to have a fair and a proper understanding of how the DSO, firstly on their mandate and how they operated in relation to the other unit of the NPA, as well as the South African Police Service, and in particular the topic at hand, how the TRC were handled then or ultimately left the DSO.
So in 21, you then deal with the Directorate of Special Operations, the DSO.
Correct.
Sit and read that and explain it.
It reads, the DSO, commonly known as the Scorpions, was a specialized unit within the NPA, formed by the South African Parliament in 1998. It was tasked with investigating and prosecuting what they referred to as high-level and priority crimes, including financial crimes, organized crimes, and corruption. It was an independent and multidisciplinary unit with a unique methodology, with combined investigation, forensic intelligence, and finally prosecution.
So if I may pause there, what you're saying is that this was a specialized unit, correct?
Correct.
You say it dealt with high level and priority crimes.
I confirm.
And also organized crime and corruption. So in other words, high level, very serious crimes.
That was the intention of the legislature, and it is so in the Act itself.
Thank you. So you may proceed.
Paragraph 22, the NPA then was headed by Advocate Nuka, who had 4 Deputy National Director of Public Prosecutions who reported to him. We named the 4 divisions, as the first one being the National Prosecution Services, NPS, which was responsible for the day-to-day prosecution of cases in the district, regional, and high courts. And this was headed then by Advocate Jan Henning. The second division was the Asset Forfeiture Unit, which was headed by Advocate Willie Hofmeyer. The third division dealt with all the specialized division within the NPA. At that time, these were the Priority Crimes Litigation Unit, referred to in abbreviation as PCLU, the Specialized Commercial Crimes Unit, SCCU in abbreviation, as well as the Sexual Offenses and Community Affairs Unit, called SOCA then, which the third unit was headed by Dr. Silas Ramaite, SC. The fourth division was ours, the DSO, which was headed by Advocate McCarthy.
And then in 23,
You're speaking softly, Mr. Narani. Can you speak up?
Mr. Dwama, in 23,
23, we're saying the DSO operated along a model of 4 desks, which existed when I joined. The first desk was the Financial Crime Desk, that's how it was referred. The second one, the Public Corruption Desk. The third was the Racketeering and Prevention of Organized Crime Desk. And the fourth was the Organized Crime Desk, which I then headed prior to my elevation.
if we can go back briefly to paragraph 22, where you talk about the specialized divisions. I don't know if you deal with the explanation about what each division was doing, but the Priority Crime Litigation Unit, do you expand somewhere or do you want to deal with it here?
I think we highlight the proclamation that created it and their core mandate in some way later in the affidavit.
Okay, thank you. And then 24.
24 is just to highlight that the DSO operated on a so-called proactive troika methodology type of investigation. This then meant a complete integration of investigators and prosecutors being assigned on each project. Sometimes there would be accountants and or other experts where needed that will be assigned to a specific project on each of the DSO authorized projects.
And then in paragraph 25, you deal with the period in March 2003.
Yes, I confirm that I was appointed then as the deputy of the head of the DSO. In terms of the act, it was called investigative director and or head of operations, being overall in charge of all the investigation and prosecutions in the DSO. The DSO then had investigation and prosecutors in the region. We had regional offices in Gauteng, Western Cape, Eastern Cape, KwaZulu-Natal, and Free State. Those were the regional or provincial offices. In 26, we highlight that at head office we had also subdivisions, the first one being called Crime Analysis Division, CAD, CID. The second one that has been mentioned in this commission being the National Project, Special National Projects Unit, SNPU.
If you may pause there, can you explain just briefly what the function of the SNPU was? Or do you want to leave it for later?
I can do it now. The SNPU
Just briefly,
initially was a sort of a specialized project based in the office of the National Director. And when I joined the DSO, or shortly after my appointment, it was decided to move it from the national director and allocate it to within the DSO because they were then investigating DSO authorized projects, and they were appointed as special investigators within the DSO. They came along carrying a few TRC cases which were then lumped together with them in that unit. So they had two divisions, TRC cases and genuine DSO type of authorized investigation or projects.
I know we'll come to the deal. I just wanted to just have an overview of what it does, but we know we'll deal with the case that we're dealing with at the particular time.
I confirm.
Yes. Paragraph 26, you say if you continue.
There were also ad hoc projects divisions, one being called Crime Intelligence Collection Unit, which worked hand in hand with the SNPU. Then we had the normal HR, Human Resource Division, and the training departments. In 27, again, that's where I highlighted how the SNPU came into being. It was initially located in the NDPP's office, and that's where I met Advocate Chris McAdam, as then he was located in the NDPP's office, with whom I dealt with on some TRC cases. And the last sentence says the SNPU later formed part of the DSO, and they were all reporting to me.
And then 28.
Just under 27 in paragraph on page 1723, Chairperson.
Page 1723.
Yes.
Just
We have an annexure.
yes.
Or which shows the identification of SNPU and KIKU, CIU, Crime Intelligence Collection Unit, as they were working together and identifying cases as existed in that unit by 2003. The first group of says SNPU TRC files.
But before you go there, in other words, you are saying the unit CCU and SNP had files existing we were dealing with at the time.
In 2003.
2003.
And they were grouped into two. The genuine, I'm going to say the genuine DSO authorized projects under the National Projects Office, and the second group was the SNPU TRC files that they came along from Mr. Nuka's office.
I know you deal with the projects office later,
Yes.
but that's what you referred to. You said, when you say genuinely authorized projects, this would be authorized in terms of the legislation.
Correct.
And then SNPU TRC files?
They brought them along from the National Director's Office, and because Mr. Advocate McAdam was then stationed in the SNPU, he managed to run those investigations maybe for 2 or 3 months in the DSO.
These are the TRC offices.
The TRC type cases, files.
And that would have been prior to the creation of the PCLU.
That was prior to the creation of the PCLU.
And as we know, until the PCLU was assigned part of what their functions were, they were assigned TRC cases as priority crimes.
I think so that we follow. It's March 2003, SNPU is located from the NDPP's office to the DSO. April, there's an additional proclamation by the President creating the PCLU with a specific mandate. And in May, Mr. Nuka decided, and it was approved by the NPA EXCO, to identify the TRC cases as, the right word was specific offenses and that they're going to be located not anymore in the DSO but within the PCLU. The initial proclamation of the PCLU did not include TRC cases.
All right. We will come back to that in a bit more detail. But in paragraph 29, you deal with the turf war between the DSO and SAPS.
I confirm, Chairperson.
Why do you think it's important for you to deal with that topic?
It is important as later on, or it has already been evidence that there's been what we called a turf war between DSO then and SAPS on the core mandate of each of the two units, but later relevantly as to who between the two was supposed to do TRC investigations.
And at that time, you were not in SAPS.
No, I was never in the SAPS.
You were in the DSO.
I was in the DSO in the NPA.
And the question should be, who must investigate the cases,
That came up later.
particularly the TRC cases for these purposes?
Correct.
Okay. Yes.
Because everything started after in paragraph 28,
Yes.
after the President Mbeki handed in the report in March 2003, and he made the speech on the 15th of April 2003 that the handling of TRC cases was handed over to the NPA.
Correct. And that's how you locate the turf wars between DSO and SAPS.
That
And then-
also correct.
Yeah. Yes. Then you deal with this matter again on paragraph 29. Can you expand on that? Paragraph 29.
I think the commissioner then was the late Mr. Jackie Silibe. He wrote to the national director, Mr. Nuka, that there's been a complaint. That's how it started, a complaint that DSO has downgraded their mandate. Instead of focusing on these high complex cases, we were now doing run-of-the-mill type of cases for quick wins and running to the TVs and taking the work away from SAPS. This then resulted in meetings, and we ended up signing sort of civil level agreements where we agreed that DSO or Scorpions will focus on its core mandate as it was then defined in the legislation, and let the SAPS also focus on their core mandate with their relevant type of cases.
Paragraph 29, the next sentence, you say, I was even part of management meetings. Just read that out.
That is what I just mentioned, that between the two units, there were many management meetings where we ended up agreeing on the way forward and signing service level agreements, each focusing on their core mandate.
And in paragraph 30, you emphasize that your understanding of the mandate of the DSO was to investigate complex, high-profile matters of financial crimes, corruption, and organized crime.
That is correct, as defined in the Act. It was not that the DSO or Mr. Nuka, the NPA, created the mandate, but it was defined in the legislation.
And then in paragraph 31,
In line with what we agreed with the SAPS, or even prior to my taking of office, we created an intake of cases where there was a project management office which received and registered all referred DSO matters, which were initially for consideration, approval, or refusal.
so this will ensure that you deal as DSO with matters that are within the mandate of the DSO.
Correct.
Yes. And then 32,
So the project management office will first assess if it falls within those four desks or core mandate. And as before, there were deputies running each of the desks. They will then refer that file to the desk, who will assess the matter and then refer it to me for approval or not. And each file was then referenced with its unique file number.
So in other words, you would have the final say of where to direct the particular matter to.
Correct.
You would say this is a commercial crime, it must go to the financial desk.
Correct.
This is a sexual crime, it must go to the relevant desk.
You mentioned sexual, we didn't do sexual. High financial crimes or corruption or organized crime.
Okay, thank you. And then from paragraph 33, you deal with your position as head of operations of the DSO from 2003 to 2005.
Correct.
Can you explain that?
I point out that I was appointed as the head of operation stroke investigative director of the DSO from 1 March 2003 until 30 June 2005.
If you just pause, when you say head of operations, what did that entail?
The legislation identified the position as an investigative director. And we, because of the position applying to the person being the head of operations, the title just followed, but it is not in the Act. And it ran also, the person occupying that rank was the second in charge of the Scorpion, deputy head of the, so I ran 3 ranks in one.
Yes, may proceed with paragraph 33.
I read it further, I say I deem it necessary to refer the Commission to the applicable legislation regulating the parameters of my functions then. This is to enable the Commission to locate the misguided allegations made by the Kalata Group and Advocate Ackerman SC and McAdam that I stopped the investigation and prosecution of TRC cases. Understanding my role within the confines of the law will provide much needed clarity to the Commission, Commissioners and Chairperson.
Yes, and 34.
My position as head of operations was regulated by the NPA Act 32 of 1998. The NPA Act gives effect to Section 179 of the Constitution. At all material times, I was obliged to carry out my functions in line with the Constitution, the NPA Act, and the existing NPA policies. Overarchingly, I was to act independently and without fear or favor.
35.
We highlight that the position of the head of operation was introduced in the NPA Act through an amendment of the Act in 2000. And for purpose of the record, we cite in full the Section 7. Firstly, the Section 2 on page 1705. Where Section 1 says the Principal Act is hereby amended, brackets A, by the insertion after the definition of director of the following definitions. Directorate of Special Operations means the Directorate of Special Operation established by Section 7, brackets 1, brackets A. Head of Investigating Directorate means the Deputy National Director referred to in Section 7, brackets 3, brackets A, or an Investigating Director referred to in Section 7, brackets 3, brackets B, as the case may be. If I may clarify, Chairperson, the first one being the Deputy National Director being referred there would be Mr. McCarthy or Advocate McCarthy as the head of the Investigating Directorate, the head of the DSO. And the second one, the Investigating Director, then was myself.
So you were an investigating director?
Correct. The Investigating Director means a Director of Public Prosecutions appointed under Section 13 to the Directorate of Special Operation, or as the head of an Investigating Director established in terms of Section 7, brackets 1, capital A, close brackets. This is essentially meant that the rank of special investigative director was equivalent to a director of public prosecution on a provincial level.
Okay, that's why it says investigating director means the director of public prosecutions.
Yes, the rank were the same.
Yes, may proceed.
In paragraph 36,
Yes, you do.
we quoted the then section 7 as it existed, and in particular subsection 1 capital A, which reads as follows: there is hereby established in the office of the National Director an investigating directorate to be known as the Directorate of Special Operations, DSO, to investigate and carry out any functions incidental to investigations, subparagraph A, relating to serious, high-profile or complex corruption, commercial or financial crimes, and organized crime. This is the core mandate as it was defined for the DSO, then chairperson and commissioners. Roman figure 1, also matters referred to the investigating director by the national director in terms of section 28(1)(b), or referred to the Roman figure 2 referred to the investigating director in terms of section 28(1)(a) or 28 brackets 13.
I know you come to this later on, you explain it, but just to explain it further. So you understand 1A says this deals with the investigating director.
Correct.
He may investigate matters relating to serious, high-profile, complex corruption or commercial financial crimes and organized crimes. That's the function of the investigating director.
And to our understanding then, this was the core mandate of the DSO and nothing else.
And then Roman figure 1, which you just read, the national director may also refer matters.
Correct. There was a provision in the NPA Act under 28 brackets 1 brackets B, which gave the national director overriding powers on type of cases. He would direct the special director or the investigative director to investigate, even though they did not strictly fall within the mandate of the DSO.
You may proceed.
And the Roman figure, the other in page 1706, relate to the legislative parameters of the mandate, being the prevention of combating of corrupting activities of Act 204, 12 of 2004, as well as the Prevention of Organized Crime Act 121 of 1998.
And what were the additional related statutory offences or categories of statutory offences?
These are the two that I mentioned under B, Roman figure 1, and B, Roman figure 2.
Was it limited to just those two?
At the time, correct.
At that time?
Correct.
You may proceed. 37.
As the head of the operation or investigating director, I was the only person who could authorize an investigation in the whole country in terms of section 28(1)(a) and 28(13) of the NPA Act.
Just explain that.
I think if we read first 28(1)(a) as well as 20(a) in paragraph 13, then I can explain.
Proceed.
The subsections are then referred to in full under paragraph 38, Chairperson. The first one being 28 brackets 1 brackets A, which reads as follows: if the investigative director has reason to suspect that a specified offense has been or is being committed, or that an attempt has been made or is being made to commit such an offense, he or she may conduct an investigation. And the word may is highlighted though, and I'll explain. The next one is section 28(1)(b), which says if the national director refers a matter in relation to the alleged commission of a specified offense to the investigative director, the investigating director shall conduct an investigation or preparatory investigation as referred to in subsection 13 on the matter. We included section 28(2)(d), brackets 2, brackets D, which reads, if the investigative director at any time during the conduct of an investigation is of the opinion that evidence has been disclosed of the commission of an offense which is not being investigated by the investigating director consent, he or she must, without delay, inform the National Commissioner of the SAPS of the particulars of such case. And the last one is section 28, brackets 13. If the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of section 28(1)(a), the investigating director may hold a preparatory investigation.
You are going to go back to 37 then to explain.
Correct.
You wanted to read 28(1)(a), 28(1)(b),
In terms
and how they relate.
Yes, the overriding power to the investigative director is in terms of 28(1)(a). And he is fettered with a discretion. He considers a matter that must strictly fall within those four type of mandated offenses. And the word may then says he's got a discretion to approve or decline such a request. And once it's authorized, it is a DSO investigation, and we call them projects. Under B, the word is shall. So it says once a matter is referred to the national director, apart from us, and he considers it deemed to be investigated by the DSO, he had the powers in terms of that subsection to refer a matter, even though it did not fall within the confines of the mandate. He then directs it to the DSO, and the head of the directorate has no option. The wording says shall. It was sort of a directive, compulsory, shall then conduct that investigation. And under D, as 2D also says, those type of cases not falling under DSO must be referred to SAPS. That is our understanding of the legislation.
Thank you. So you had a discretion, but if the national director said you must investigate, you didn't have a discretion.
I did not have. I was compelled to do that.
Yes. May proceed.
Under 39, we highlight that specified offenses. If we go back to 28(1)(a), the preceding paragraph 38, it says specified offenses, which are then, that is the only type of offenses that the DSO could investigate. And then in 39, they are then defined within the Act as to what are specified offenses. And it read that any matter which, in the opinion of the head of an investigating directors, falls within the range of matters as contemplated in section 7, brackets 1. We highlighted that 7.1 read that offenses related to serious, high profile or complex, 1, corruption, 2, serious, high profile or complex commercial or financial crime, 3, serious or high profile or complex organized crime cases, and lastly those relating to racketeering and the prevention of organized crime. So these were the four core mandate of the DSO then.
And then in paragraph 40,
as I mentioned earlier on, Mr. Nquka as the NDPP saw it fit in April 2003 to declare all TRC cases as priority crimes and place them within the newly established unit called Priority Crimes Litigation Unit, abbreviated as PCLU. The PCLU was established in terms of a presidential proclamation in March 2003, and it was responsible for certain identified also priority crimes that were defined in the proclamation. If we can take to paragraph 43, that's where the type of priority crimes identified in the proclamation for the creation of the PLCU then are identified. And it says in paragraph 43, the PLCU was mandated to quote, to direct investigation and prosecution in relation to various priority crimes, including, as identified in the proclamation, serious national priority crimes such as terrorism, sabotage, high treason, sedition, and international crimes.
Earlier you said that Mr. Ncuka had also said that these TRC cases were specific offences. What did you mean by that?
Initially, they were not. They were not identified. If we follow the mandate or legislative mandate of the DSO, they are not included there. They are not covered. But they came along and they are located in the DSO. PCLU is created with this mandate, also not covering the TRC cases. He then decides, in order for them to fall within the PCLU proclamation, to identify them as defined in the Act as priority crimes.
Priority crimes.
And then he upscaled them from ordinary cases to priority crimes, and now they formally fall within that proclamation.
Thank you. Thank you.
And then while we are there, just the reporting lines, just to get back. There's PCLU, there's DSO,
Correct.
and they all fall under the NPA.
Yes, when we did the 4 divisions, subdivisions in an earlier paragraph, I highlighted that Dr. Ramaite was in charge of all these specialized new units. All of them were new in 2003. The SCCU, the SOCA, and now the new PCLU. They were then reporting directly to Dr. Ramaite, and the DSO was separate from them, reporting to Dr. Advocate McCarthy. And the two, together with the other 2, were then reporting to Mr. Ncuka.
You were
On paragraph 42.
42 years. But just
Sorry, under 41,
Under
I'm
41
saying,
years, yeah.
we said it was the decision of the NDPP. Obviously communicated to the NPA EXCO management. It was endorsed and it became an official NPA policy that now TRC cases from that day are now located within the PCLU.
And as you testified earlier, they were in the SNPU at some point.
Correct.
They then went to DSO, and then DSO, they transferred to PCLU,
If we now follow this new policy.
the new policy.
Correct.
All right. Yeah, you may
And
proceed.
it is highlighted in paragraph 42.
Yes. Just read that for the record.
We're saying following upon this new policy, it was agreed that all TRC cases that were located within the SNPU of the DSO had to be transferred to the new PCLU. And that is around March, April 2003. As indicated, the PCLU reported directly to Dr. Silas Ramaite. The DSO was therefore not responsible for the investigation and prosecution of TRC cases since the inception of that policy. I've already dealt with paragraph 43, Chairperson and Commissioners. But under 44, we highlight that the PCLU was therefore clothed with both investigative and prosecutorial powers from that proclamation that created it. The challenge, however, that I have to mention, Chairperson, was that no specific investigators were employed or assigned to the PCLU from its inception.
So if you may pause there. In paragraph 43, you summarize the proclamation,
Correct.
and which said the PCLU is mandated to direct investigations and prosecutions. So both investigations and prosecutions.
As highlighted in the proclamation, correct.
But you say in practice, they didn't have any investigator.
Well, at inception,
At
during
inception.
my time there, they were they never appointed or assigned investigators to PCLU.
Thank you. You may proceed.
In 45, paragraph 45.
Why was that so? If there's a proclamation, it specifically says you'll be assigned you'll do investigations. Why were they not assigned investigators? Do you know?
I would say that was above my pay grade. I don't know.
You may proceed.
In paragraph 45, we say, maybe to answer that, it was the understanding of the NPA exco management meetings where Dr. Ramaite was in attendance that the investigation of the PCLU would be done by South African Police Services in accordance with the constitutional mandate of the South African Police Services.
And you were part of the NPA exco management,
Correct.
and that was your understanding as well.
Correct.
You may proceed.
46, the Kalata Group in their papers allege that when the PCLU, through Advocates McAdam and Ackerman, approached Commissioner De Beer, who was the divisional commissioner of the South African Police, Mr. De Beer advised them that the NDPP, being Advocate Bulelani Ngcuka, must approach President Mbeki for a decision on who should investigate the TRC cases between the DSO and SAPS.
I think if you may pause there, Chair, I realize it's 1 minute to,
Yes,
if you may pause here.
yes.
Thank you.
This might be an appropriate time to adjourn for tea. We'll reconvene at 11:15.
In paragraph 36,
Yes, you do.
we quoted the then Section 7 as it existed, and in particular subsection 1 capital A, which reads as follows: there is hereby established in the office of the National Director an investigating directorate to be known as the Directorate of Special Operations, DSO, to investigate and carry out any functions incidental to investigations, subparagraph A.
Thank you, Mr. Nalane.
Thank you. Mr. Dwama, we were just dealing with paragraph 46, and you're about to deal with paragraph 47.
I confirm.
Yes. Can you read 47 and then comment?
In paragraph 47, in his testimony before this commission, Commissioner and Chairperson and Commissioners, Advocate Ngcuka said there was, following what Mr. De Beer advised Advocate McAdam and Ackerman for him to approach, or for him to approach the President. He said there was no need for him to approach the President, as all TRC cases under the mandate of the PCLU were understood to be investigated by SAPS, South African Police Services.
I think just to put a bit of context, De Beer was Divisional Commissioner of the South African Police.
Correct.
And as we read from the papers and some of the evidence we have had, Advocate McAdam and Advocate Ackerman SC said they approached SAPS.
In
particular,
August
Mr. De Beer.
2003.
Yes. And there they were encountering difficulties with getting the cases investigated.
Correct.
And when they asked De Beer to assign investigators, he wrote back to them and said, as far as he understood, the PCLU was the one assigned to investigate TRC cases.
No, I think his letter read that according to him, the president says NPA cases, TRC cases must be under NPA, and his understanding was that DSO will then investigate the TRC cases, as those police, most of those police that dealt with them have moved or been appointed as investigators within the DSO. That was his understanding.
And then he said, if you need the mandate to be changed, go to the president.
If you need clarity, we would, he's saying, I think, along the lines that SAPS will only get involved once the president has clarified or instructed them.
And so the impression is that the SAPS refused to investigate the TRC cases.
I'm not in a position to answer for them.
That's fine. Then you can proceed then.
In 48, I say all PCLU cases then were investigated by SAPS, and none since that proclamation were ever declared or investigated as DSO projects. I'm highlighting a few cases that I'm aware of that were dealt with by PCLU and investigated by SAPS. The first one is in 48, subparagraph 48.1, referred to as the state versus Geyser and Visser. This was a matter investigated by SAPS and managed by, I have to correct that chairperson, it must read PCLU and not SNPU. I missed that when we did corrections. It involved nuclear weapons grade uranium enrichment with a plant to Libya. The SAPS arrested the directors of Cash Engineering Pty Ltd, and the matter was prosecuted by PCLU in the Pretoria High Court. The second one is under 48.2, referred to as State versus Asher. I'm not sure how to pronounce that surname, Karn, K-A-R-N. This matter was also investigated by SAPS in Cape Town and managed by the PCLU. The investigation dealt with import of nuclear devices to South Africa then. 48.3 refers to other foreign military assistance cases, such as the then arrest of South African citizens in first group in Zimbabwe, another group in Equatorial Guinea, which were all investigated by SAP, South African Police Service, and prosecuted by PCLU.
But the point you're making in 48 is that all PCLU cases were investigated by SAPS.
Correct.
And you
And
say,
to support
you say
the-
none were ever declared or investigated as a DSO project.
Correct, which would have entailed that DSO investigators are assigned to them, but none were ever dealt with within the NPA Act.
Yes.
The proclamation for them was separate, and the proclamation and legislation for DSO was separate.
Proceed to 49.
49, we're saying in line with that NPA, new NPA policy of declaring TRC cases and transferring them to PSLU, and their mandate to investigate priority crime, then including TRC cases. The head of the DSO, being Advocate McCarthy, confirmed that all TRC cases that were within the DSO, that is now in 2003, Chairperson, were to be transferred and formally handed over to the PCLU. This occurred at the same time when I signed my performance contract with Advocate McCarthy. Therefore, the TRC cases, save only the two matters that Advocate Nuka insisted that I, as head of DSO, must attend to them, were further not included in my performance indicators to be measures for purpose of my employment contract.
What do you mean by that? Go ahead.
I'm simply saying when I signed my performance contract, TRC matters were not part of that because they were transferred to PCLU and they did not form part of the mandate of the DSO. They were not covered under my assessment or performance contract.
And then at 50,
In line with what we had just discussed, I requested the Project Management Office, which was headed by Chief Investigating Officer Mr. Caspar Jonker, to provide us, the DSO management, with an audit of all matters that had been investigated and dealt with by the SNPU then. Mr. Jonker prepared the audit, and I attached that audit as an extra MGL1 as the list of all cases that prevailed in the SNPU then.
Yeah, Mr. Dawn, what I suggest we do, because the list is quite long, right, but just highlight the heading without, unless it's necessary, to read each and every project.
I think maybe just to the heading and say it's 5.1 to 5.11 to 5.110, and then the next heading, because it's a long list.
But where is necessary to highlight specific cases which you think might make the point? Don't hesitate to do that.
Correct. Thank you. In paragraph, subparagraph 51.1, we identified those that are referred to as genuine DSO authorized projects that were under the CICU, and SNPU projects.
In other words,
They are 10
this would have gone through the project management office
Yes.
and then assigned.
and authorized in
And
terms of 28(1)(a),
Thank
all of these 10 projects. I don't think they are not relevant for purpose. I don't have to read them, Chairperson. 51.2 is the relevant ones, which are headed as SNPU TRC cases. And we have listed, according to Annexure MGL1 in page 1723, 14 of such TRC, as they were called, TRC cases that existed in the SNPU then.
And then 51.3 you deal with closed
50
case, closed files.
Yes, we also highlighted those files that were closed according to the project management. And I think only one there is relevant for purpose of the memo that referenced by Mr. Lisk and attached to the papers.
And just, if you cast your eye through the list of the TRC cases which you were involved in auditing and handing over on page 1711. Does any one of those, are you aware if any one of those cases were prosecuted?
If you mean then, I don't think any of these were prosecuted then.
At the time?
At the time, but I've been following.
Subsequently? Yes.
I've been following the proceedings of this commission, and I hear that subsequently, after I left, or even now, some are only being attended to as late as 2024 and 2025.
This is what you have learned through following the proceedings of the commission.
Correct.
And then if you turn to page 1712, page 52.
Paragraph 52.
Yes, paragraph 52, yes.
In line with my understanding of the NPA policy, I formally and officially transferred all TRC cases that were within the SNPU of the DSO to the PCLU.
Then paragraph 53.
On 15 July 2003, after I had taken the decision to transfer the TRC cases to the PCLU, I issued 2 memoranda. One addressed to the then head of SNPU, Advocate Tongwane, and Obed Tongwane, and another to the Chief Investigating Officer within the DSO, Mr. Andrew Lisk, who has already testified before this commission. I've been unable to locate the one that I addressed to Advocate Tongwane, but the one that I addressed to Mr. Lisk is annexed here to as Annexure MGL2. And I know it has been also attached to the Kalata papers. In 54, we quoted the memo in full, and if I may read the contents there too.
Is it important to read them, read the content?
Sorry?
Why do you want to read the whole of the excerpt?
I think this is the numb of my evidence. I've been accused that based on this memo, I, on behalf of the DSO or on behalf of whoever, I took the decision to stop TRC cases being investigated or prosecuted and or stopped DSO investigators from being involved. And the authority of that notion is being used referencing this memorandum.
Go ahead.
The memorandum is MGL 2, which is in page
1724.
1724. Thank you, Commissioner. The memorandum is referred to, headed as an internal memorandum, which I addressed to CIO Lisk. And as I said, he already testified before this, and it's from myself, and the date is 15 July 2003. The subject is SNPU investigations. Paragraph 1. I say, due to the recent creation of the PCLU, it has become necessary to redefine the mandate and operation of the SNPU as follows. Roman figure 1, identify TRC cases. And I quote, I have decided that South African Police Services, SAPS, must take over the investigation of all such cases currently handled by you. And by you, Chairperson, I mean the SNPU. Your files should be closed off and all materials given to the PCLU. It must also be given the storeroom currently being used. Just to amplify here, the TRC were stored in a separate storeroom there. And because we're moving them to PSLU and SNPU does not make use of it for their core projects, we said they must transfer that storeroom with all its containers to PCLU.
So was the SNPU and PCLU within the same building?
Correct. We were all in at the VGM building at head office.
Yes, proceed.
Notwithstanding the above decision, Advocate Tongwane must finalize what was called Black Cats and Winnie Mandela cases. And I amplify that this is due to the fact that the National Director of Public Prosecution has requested a speedy finalization of the two matters, and this must be done before 30 July 2003. Just to explain here, Mr. Ncuka, when he transferred or took decision that TRC cases are now transferred, he used 28(1)(b) that we authorize these two, and the two remained as DSO investigators and prosecutors. Mr. Tongwane was the head of the SNPU and as a prosecutor dealing with all matters in the SNPU. So he was tasked together with his team to finalize these two matters of TRC related by 30 July 2003. I continue, it may be necessary for, this is I'm now addressing to Mr. Lisk, I say it may be necessary for your SNPU investigators to introduce certain witnesses with whom they have dealt to the South African police investigators.
Mr. Dwaba, have you read the sentence, I transfer the two researchers?
Sorry, I missed that. After July 2003. It reads, I've also transferred the two TRC researchers to the PCLU. I highlighted earlier on, but here it is in black and white that as Mr. McAdam testified, the DSO then had employed two TRC researchers. Their core mandate was to deal with TRC cases. So when the TRC cases are moved out of the DSO to PSLU, they also moved along with the TRC cases to go and assist Mr. Ackerman and his team. It may be necessary for your investigators now, this is the SNPU investigators or DSO investigators, to introduce certain witnesses with whom they have dealt to the SAPS, South African Police Investigators, and you are accordingly authorized to conduct the necessary handovers. So to amplify again, we just did not say that's your baby TRC cases. We assisted. We transferred the cases to them. We give them manpower. We give them storeroom. We give them all the tools that we had in the DSO. They went along with the TRC cases or the files. So they had all the backing and support from the DSO.
And you testified earlier that as far as you knew, all PCLU cases were investigated by the SAPS.
That is correct. And that's how I highlighted there that the first sentence, SAPS must take over of the investigation of all TRC cases currently handled by the SNPU.
That's in the opening line.
Correct.
Yes, proceed.
In sub Roman figure 2 to 5, we identify 4 projects. The first one being Operation Sunflower. Advocate McAdam
Before
will...
you proceed, this is not a TRC cases now you're dealing with. Operation Sunflower.
It's a few years ago. I think Sunflower is identified in the annexure. I think it dealt with, if I'm allowed to quickly look at...
Yes, what is the relevance of you referring it to the other matters that are dealt with in the internal memorandum? That is Operation Sunflower and Operation Black Widow.
Is to show that it was clear to us then that these are now Mr. Ackerman's babies and are to be investigated by SAPS.
But how relevant are these in relation to the inquiry we are conducting?
I think the only one that is maybe relevant is the final curtain, which was then handled personally by Mr. Ackerman himself, and the foreign mercenaries that were identified in their proclamation that we transferred formally to them, Roman figure 4 and 5.
But the point is that TRC case which you deal with in Roman figure 1,
Correct.
you made sure that they are transferred.
Correct.
And that you deal with, you quoted a memo in paragraph 54 in its entirety.
Correct.
Yeah, you can go to paragraph 55 now.
It is clear from this memorandum that neither myself as head of operation nor the DSO stopped the investigation and prosecution of TRC cases. Instead, I merely complied with the NPA policy at the time and transferred all the TRC cases to the PCLU. 56, it is also evident from the above memo that I was concerned that the PCLU be assisted with a proper handover. I even went further in my assistance to the PCLU by transferring the 2 TRC researchers who were located within the DSO and who had been dealing with the TRC cases, amongst other matters, to the PCLU. This was to ensure that they continue with full assistance. 57. I also made it very clear to Mr. Lisk that his handover must assist the PCLU by ensuring that the DSO investigators who were charged with the investigation of TRC cases introduce witnesses they dealt with to the SAPS investigators who were to take over the TRC cases in their assistance with the investigation of TRC cases. This is just to say we just did not dump everything on them, but we were prepared to offer them assistance and do a proper handover, even in introducing witnesses to them.
And then the next topic you deal with what the heading you say, the Gata group have mischaracterized my instructions to advocate Tongwan and Mr. Lisk in the memoranda of 15 July 2003 as a decision to stop the investigation of TRC cases.
Correct.
And you deal with that under the relevant paragraph 58 up to 60.
I confirm.
Yes. In summary, what are you saying there?
On reading the Kalata founding affidavit, especially the one of Mr. Lucanio Kalata, he seems to have made a statement in 59 that, reading from that memorandum I quoted, he comes to the conclusion that that meant a decision to stop all the TRC investigation, and he characterized that as a remarkable, and I quote him, as a remarkable decision by the DSO to stop the investigation of TRC cases.
You're quoting from paragraph 59.
59, correct.
Yes. And how do you conclude on that?
In 60, I say neither myself nor the DSO stopped the investigation of TRC cases. My memorandum to Mr. Lisk as Chief Investigating Officer within the DSO contained a decision which I took in line with the proclamation and the declaration made by the then NDPP, Mr. Nuka, that all TRC cases were priority crimes now falling within the PCLU.
So you're just carrying out your functions.
And the formal transfer from DSO to TRC, it was not my own making, but an NPA decision.
Thank you. You then deal with requests by the PCLU's advocates Ackerman SC and Macadam for as DSO assistance.
Correct. As we initially said that the proclamation gives them investigative, it gives the PCLU investigative and prosecutorial mandate, but they don't have investigators. Mr. McAdam, with his occupation being in the DSO, left in May 2003 and joined the PCLU. In May 2003, he, now Advocate McAdam, in his capacity as Deputy Director in the PCLU, filed applications in my then office requesting that I declare certain TRC cases as projects, and as he used the terminology under Section 28 brackets 1 brackets A of the NPA Act, in order for the TRC cases to be investigated by the DSO. And I confirm that he did file, I think, 4 applications then. 62, this request fell outside the authority I held as the head of investigations under the NPA Act, as fully detailed in the preceding paragraphs. I then advised Advocate McAdam of my position as determined in the NPA Act, and that I could not assist him. However, even at that stage, I pointed out to him that Section 28(1)(b) of the NPA Act was applicable, and advised him that it may be prudent for him to approach the NDPP with his request. Advocate McAdam was of the view that my interpretation of the NPA Act was wrong, and he was unwilling to heed my advice at that stage, now referring to the first encounter in May 2003.
So here they're asking you to authorize and assign investigators.
In terms of Section 28(1)(a), which we agreed earlier on, it deals with the core mandate of those 4 legs, which TRC cases, strictly speaking, cannot fall under any of those.
And they've been transferred to the PCLU.
It has been formally transferred to the PCLU.
Yes, proceed.
So I don't close him off. I still advise to him that rather resort to 28(1)(b) and approach the NDPP. He will decide whether, in his opinion, this, as they are already specified offenses, he can then direct in terms of that subsection and instruct the DSO to investigate them. He did not agree with me then.
Okay.
He believed that I was wrong.
And this was the first occasion, you say it's May 2003.
That is the first official encounter I had with him as a PCLU person on TRC cases.
And then 63.
Again on about 15 July 2003, and at the request of the two, Advocate Ackerman and McAdam, we held a meeting in my office. The two of them requested me again to assist the PCLU with investigation of TRC cases, using the legislative process of declaring certain matters as projects in terms of the NPA Act. Again, they were using Section 28(1)A as their tool to have them authorized as projects. 64, I advised them again that I was unable to assist them under 28(1)A.
Then 65.
I noted that Advocate McAdam in his affidavit filed with this commission described this meeting I had with them in July as being unpleasant. In my view, the meeting was not unpleasant. I merely communicated that I would not authorize those applications under 28(1)A. Advocate McAdam was unhappy that I declined his request, and I point out that even in that meeting, I again emphasized to them that their best avenue will be to invoke 28(1)B, which they must first approach the NDPP as an option for them, as the PCLU.
66.
They were obviously not happy with my, I call it advice then to them. And in 66, I say the unhappiness over my decision and interpretation of the NPA Act is grounded in the context of my professional journey within the NPA. Both Advocate McAdam and Ackerman SC were much senior to me when I joined the Attorney General's office in 1995. I mentioned that Advocate Ackerman was already a deputy DPP then, and I was just a junior state advocate, and was way above my level of seniority in 1995. Advocate McAdam was also senior to me then. In 2003, however, I became their senior, and it appeared to me that both Ackerman SC and McAdam were not willing to accept advice from someone who they still clearly regarded as their junior. And maybe that's why Mr. McAdam ended up describing our meeting as unpleasant. 68, I say it is unfortunate that both of them, Advocate Ackerman SC and McAdam, did not follow my advice as early as July 2003. However, in December 2003, it appears to me that the penny finally dropped, and they did exactly what I've been saying to them, and they approached the NDPP, Mr. Nuka, in terms of the correct subsection being 28(1)B, as I had been advising them since May 2003, July 2003, and I will also show that I did the same in November 2003. Only then, in December, they follow my advice.
And then the next topic you deal with is the notice in terms of 3.3, which has brought you to this commission.
Correct.
You deal with that in paragraphs 69 onwards.
Correct.
The notice is attached to the bundle, so we don't have to go into detail. But you comment on what you understood that you've been accused of or blamed either wrongly or rightly of.
I confirm in those following paragraph 69 to the end.
I think 69 is, you don't have to do that as common cause.
I'll start at 71.
Yes.
It is incorrect to say that the DSO at any stage would not investigate, and a court would not investigate TRC cases. This I read from the Kalata papers. As indicated in the preceding paragraphs, I informed Advocates Ackerman SC and McAdam that I, as the head of the operation was unable to authorize the investigation of TRC cases in terms of Section 28 brackets 1 brackets A of the NPA Act, but did not stop there. I implored them to rather resort to the provisions of Section 28 brackets 1 brackets B. They were simply not prepared to accept my advice at that stage. Sanity finally prevailed and they followed this advice and approached the NDPP after some almost 6 months, only in December 2003. In paragraph 72, I deal with my third encounter with the two of them as PCLU approaching DSO to obtain assistance in investigators. If the commission remembers, after our July episode, they don't agree with me. They decide to go to SAPS. They approach Commissioner De Beer in August or somewhere in August. He writes them that letter in August 2003, and we've already highlighted where SAPS says, oh no, we can't help you, go to the president. I don't know whether they did inform Mr. Nuka, but Mr. Nuka testified that he would not have approached the president. They then in November decides to revert back to the DSO. Now that is what I call the third encounter. It's highlighted in 72. On 11 November 2003, I received a memorandum from Advocate Ackerman, SC. In this memorandum, Advocate Ackerman stated, amongst other things, that, and I quote, on 3 November 2003, he's directing this to me. On 3 November 2003, you informed me that you would assign the declaration in terms of Section 28 brackets 1 brackets B and would appoint SSI De Lange to conduct the necessary investigation. So he's confirming that I had a chat or a meeting with him on 3 November 2003 in our third encounter, where I again confirmed to him that once you obtain an approval from the NDPP in terms of 28(1)B, I would gladly approve. I have no option, it's an instruction. I would approve the matters as DSO projects and will assign. They preferred SSI means Special Senior Investigator. They identified De Lange, and I agreed that once you do that, I have no option, I'll do that. And this is what he confirms.
And then 73.
I'm saying, however, he is completely misrepresenting my advice to him. He gives it to as if I'd already agreed that bring the matters to me, I'll authorize them under 28(1)B, but that is not so. I explained to him, he knows how 28(1)B operate, I've been telling him, but I say there, it refers to the authority of the National Director. It gives him only, the National Director, that prerogative to supersede the mandate of the DSO. And I was not the NDPP, it is common cause. What I conveyed to him on the third was that he must approach the NDPP under that subsection, and if the National Director approves his request, I would then approve the project and appoint SSI De Lange from the DSO, probably with others, to conduct the necessary investigation. Just to strengthen, to say, I told him 28(1)B is available. I will accede and comply with 28(1)B, provided it comes correctly from the National Director. Only him can instruct with that word shall to the investigating director. Again, on that day, he did not do. 74, I expressly pointed to Ackerman that I've been advising the two of them all along to first approach the National Director, as he was the only one in terms of the Act to issue a directive in terms of 28 brackets 1 brackets B. Now, this is the third time I'm telling them. Then he left. Paragraph 75. On about 10 November 2003, Advocate McAdam submitted 4 TRC matters for consideration in terms of, now they left 28(1)A, they're using the correct subsection 28(1)B, and he also referred to 28(13) of the NPA Act. This included the instruction that Senior Special Investigator De Lange be designated as the investigator to deal with the 4 matters. 76. I informed in my office Mr. Advocate McAdam that the application he had forwarded to me then was again not in compliance with the prescript of 28(1)B. I again explained to both of them that I was unable to authorize the 4 matters up until they had followed the prescripts of the letter of the law by approaching Mr. Ncuka. If he agrees with them, he would then issue a directive and then we will then authorize. That's all I said to them. In paragraph 77, I say, I never oscillated in my advice to them, to the PCLU at all. I advised them to first approach the national director, which was the correct route, who would then issue the required directive and instruct me or instruct the DSO to declare those TRC cases under the DSO legislation and assign DSO investigators. That was the only way it could be done.
I think 78, 79, and 81, we can refer to MGLM 5, which is on pages 1745 and 1746. If you can deal with that by reference to.
Yes, under 78, just to remind the Commission, May 2003, I tell Mr. McAdam, he was alone, that go to the NDPP, use 28(1)B. He doesn't agree with me. July, there are 2, McAdam and Advocate Ackerman SC. I again, they still relied on 28(1)A, and again told them, please use 28(1)B. You either sign as the NDPP or you approach the correct NDPP who, after consideration, then decides to authorize them and instruct the DSO to do. They don't do it. We come to November, same script, same results. They don't do it. Now under paragraph 78, I say now it is common cause that the PCLU finally accepted my advice and directed their applications correctly to the NDPP on 8 December 2003. Then NDPP approved their request and duly signed the directive instructing me as the DSO to authorize the matters in terms of 28(1)B only on the 24th of Feb 2004. In support, I attach as annexure MGL for the relevant directive that was signed by the NDPP on the 24th Feb 2004, as Advocate Nalana said, as he has said, is in page 1745.
If we may turn to that page. Of course, you repeated in paragraph 79, but let's stick to that. What does it say? Investigation into?
The memo is originating from on top, Office of the Head, Priority Crimes Litigation Unit Headquarters. That's now Mr. Ackerman's unit, PCLU. He refers it as an internal memo, and
what it says to head
is
of operations.
Forwarded
DSO.
to head of operations, being head of operation DSO, then being myself. And it's purported to be from the NDPP. It's dated 8 December 2003, and the heading is Investigation of TRC Cases by the DSO. I quote, he says, I've decided in terms of section 28(1) brackets 1 brackets B of Act 32 of 1998 that the following, I see there's a spelling, he says 3 cases, but they listed 4, arising from the TRC be investigated by the DSO under Roman figure 1. They identified kidnapping, assault and murder of the PEPCO 3. Roman figure 2, murder of Brian Ngulunga. I think
Mulunga.
thank you.
There must be a spelling mistake.
I'm reading it as it is,
Yes.
Commissioner, and I think the main suspect was Van Rensburg on this one.
Yes.
And Roman figure 3 would be the matter of the murder of the Motherwell 4. And the last one, Roman figure 4, was the attempted murder of Reverend Frank Chikane. And Mr. Nuka then signed this on the 24th of Feb 2004.
What did you then do? This is the memo.
The memo comes to my office, obviously through the project management, and we then authorized this as DSO projects, issued the declarations, and because for every declaration by DSO, the head of operation must designate, meaning appoint and authorize investigators on each of this, and that's what we did.
It is a matter
So
of-
when they left at that stage, they had 4 matters that were now properly authorized in context of DSO, and they were supposed to proceed with these matters with the investigators under within the DSO confines.
It is a matter of record that the attempted murder of Reverend Frank Chikane matter was finalized in court ultimately.
I followed that through the press, yes, I'm aware of that. But
And then the
only
first thing-
later,
Only later.
only way later.
What do you mean only way later?
This was authorized to them in 2004. So from February 2004, they were then tasked to proceed. And I just can't remember when it was finalized in court, but not close to 2004.
And what about the other 3? PEPCO 3, Brian Mulunga, Motherwell 4?
To my best understanding, these were also recently, only attended to recently, not in 2004 or 2005. Even though they were authorized to them then,
And you learned this from following the proceedings of the...
following the proceedings and the testimony, I think, of Advocate Sings and Advocate Maha.
You have dealt with paragraph 79. We may then go to
80. In 80, I'm saying now the PCLU, being alive and appreciative of how 28(1)B should be invoked, as I've been telling them since May the previous year, they formally adopted the same procedure and submitted a further application to the NDPP in terms of 28(1)B. And I highlight this in paragraph 81, which is the submission they made on the 26th of February 2004, requesting Mr. Nuka to authorize 2 further matters in terms of that subsection 28 brackets 1 brackets B. The directive is filed as Annexure MGL 5.
This is on page 1482. I think that's it.
Just to correct the page,
the page numbering.
1482 was the initial page, probably where this was filed in another bundle. But for our part, it's 1746.
It should be 1746.
It's
Commissioner.
there on top, 1746, page 1746.
Yeah, oh, you're right. It appears there, yes. Just take the commission through this.
The memo is issued under the Office of the National Director of Public Prosecution heading, but on the right it shows that it's from the Priority Crimes Litigation Unit, being Advocate Ackerman's unit. And it's addressed to Advocate M. Gili Dwaba, Head of Operation, being issued from the NDPP, is dated 26 Feb February 2004, and they had reference number of 2 TRC matters, 25/02 and 18/02 TRC. Heading is a referral of TRC cases to the DSO in terms of section 28/1(b) of Act 32 of 1998. Mr. Ncuka says, I've decided to refer the following matter to the DSO for investigation in terms of section 28(1)(b) of Act 32 of 1998. Crimes of murder, attempted murder, and conspiracy or incitement to commit murder committed in an organized fashion by Letlapa Mphahlele with reference to the Appler attacks on the St. James Church, as well as in Heidelberg Tavern situated in Cape Town. He signs it and titled National Director of Public Prosecution. So I know he signed this on the 26th of February because it was submitted to our office on the same day.
And what did you do with that instruction? You did
Again,
it at
which
paragraph
is
82.
82. The legislation says I shall. I have no discretion. There once it comes under that section. I complied with the instruction of Mr. Ncuka and I authorized the 2 matters as properly DSO projects, and DSO investigators were then assigned to assist in these matters.
And then paragraph 83, what do you say there?
I said it is
Paragraph 83, yes. page
83, yes. I'm saying it is inexplicable and confounding to me why the PCLU, now being aware that they have a tool, 28(1)(b), which they've been refusing to follow, only resorted and used it only on the 6 matters, the 4 on the 24th of February and the 2 on the 26th of February, leaving out the rest of possibly ripe matters that they could have similarly approached Mr. Ncuka. He would have authorized them under 28(1)(b), and I would have been obligated to authorize them as DSO investigators.
And then paragraph 84.
Reading from the papers, I noted that Advocate McAdam contends in paragraph 39 of his affidavits that I, as being Ledwaba, failed to respond to Advocate Ackerman's memorandum of 10 December 2003. 10 November 2003, my apology. I disagree with Advocate McAdam's contention.
85.
To show that I disagree, I say it is common cause that I engaged with Advocate Ackerman on his memorandum to me on the 10th of November. And Advocate Ackerman, as he confirms our engagement and states, if I have to quote his word, he says, after he approached me, talking to me, I was unmoved by his plea. So Mr. McAdam is probably mistaken.
And what was this meeting or the memorandum all about?
That was now the 3rd encounter where they approached the DSO to assist them.
It was about the DSO appointing investigators.
Authorizing the TRC projects as DSO projects and designating and assigning investigators to them.
Then 86.
I say it is significantly it is incorrect that I was unmoved and tone deaf to the TRC cases. It is I who advised the 2 of them, Advocate Ackerman SC and Advocate McAdam, since May 2003 to adopt section 28(1)(b) of the Act and to ensure that DSO investigators would be appointed and designated to assist them in those matters.
And 87.
I further note that McAdam states in paragraph 40 of his affidavit that, and I quote him, he says, on 8 December 2003, NDPP Ncuka, acting in terms of section 28(1)(b), instructed Ledwaba to have 4 TRC cases specified and referred to be investigated by the DSO, close quote. I say he is obviously incorrect in this regard because it is clearly incorrect. The NDPP only directed and instructed the DSO not on 8 December as he claims, but on 24 February first time, and again on 24 February, and not on the 8 December as he says.
And 88, you deal with the 6, or you deal with appointment of senior investigators to assist the PCLU.
Yes, I think when Mr. Our Advocate McAdam testified, he also mentioned this aspect, that in their quest to investigate TRC cases, PCLU, being him and Advocate Ackerman, approached the NDPP and NPA senior management and made a request that 6 DSO investigators be seconded to the PCLU unit. And I say I'm also aware that this request was not acceded to by the National Director, Mr. Nmuka, and his team, in particular, then being Dr. Ramaite and Advocate McCarthy. I'm aware of that.
As we testified earlier, the PCLU was created by declaration, by proclamation.
Correct.
But they didn't have investigators.
Correct.
So here, it looks like they were asking for investigators to be assigned to them now.
Correct. I think that was around just before they approached SAPS in August 2003.
And you say that request was not acceded to.
Correct.
Yes. Deal with 89, you deal with that issue again?
I'm simply confirming to the Commission that I think I can confirm that the overriding factor in refusing this request, they mentioned specifically 6, because they knew SNPU employed 6 investigators. So the request was refused because the available capacity of investigators within the DSU. They picked 6 because SNPU had only had 6 investigators then. So if these investigators by then were saddled with the investigation of the highly complex DSO genuine authorized projects that we identified in that annexure. So if this request had been acceded to, nobody would have been remaining in the SNPU to deal with those projects, and would have had to close the SNPU. So that's essentially why that request was declined.
And you say SNPU was dealing with serious cases.
Correct. At national projects, those that we identified as national projects with the aim of quick wins. Those were identified that they can be finalized quickly, and DSO can then celebrate on those successes. The regions had long and complex cases that took some time. That was the main purpose of the SNPU.
And then paragraph 90.
The Kalata affidavit states that the DSO persisted in its refusal to appoint investigators, as did the SAPS. This is what is in the papers. It is alleged in those papers that, according to McAdam, the refusal by the DSO to provide investigators effectively brought an end to the investigation and prosecution of TRC cases.
And what's your answer to that?
I'm simply saying in paragraph 91 that this is an incorrect representation of the context within which the DSO and the PCLU interacted regarding the investigation and prosecution of TRC cases. I think I've already highlighted what happened in the preceding paragraphs. In 92, I say the DSO authorized, notwithstanding what Mr. McAdam says, it is common cause in 92 that the DSO authorized investigation of at least a total of 6 TRC matters as directed by the National Director in 2004. And this was by their request. So for him to say there was an effective bringing to an end of investigation, I'm shocked. 93, in my view, PCLU had no impediments from pursuing any new investigation of TRC-related cases, I meant to say, utilizing section 28 brackets 1 brackets B by simply approaching the NDPP, and if he was happy, he would then direct and approve it, instruct the DSO to do, and will do like we did with the 6.
you explained here in 94.
The last application they made into, the last application of the PCLU made in 2003 was on 8 December 2003.
And if you may pause there, that application was granted.
Correct, as we said under 1745.
Yes.
The
Proceed.
memo by the NDPP was authorized. He approved it on 24 February on only 4 matters that was identified, and he instructed the DSO to further authorize 2 other matters 2 days later, 26 Feb 2004. So in total, they decided to apply for only 6, and these were approved.
And could they have applied for more?
Nothing stopped them. Oh, well, I cannot really talk on their behalf, but from my perspective, they had at least, according to their audit, more than 40 cases then that were alive, and they decided to focus only on the 6, which we now know were only finalized long after, long after 2004.
And then, what do you say in paragraph 95?
I wish to stress to the Commission that the DSO never stopped or refused to investigate TRC cases. It is clear we handed over, cooperated, and gave them even advice on how best for them to deal. They disregarded that and only accepted in December, when this could have been done as early as May. So to say the DSO stopped or refused is not correct.
Before you conclude, there's one matter that I want your views on.
Just speak up, Mr. Nana.
Before you conclude, I just want to ask one question which you may or may not be able to comment on, but you'll inform us. You mentioned in your affidavit that in 2003, former President Mbeki made a speech in Parliament accepting the final TRC report. Correct?
Correct.
And you were dealing with the DS, and you also say that at some point the TRC cases were made priority crimes. Correct?
Correct.
And it is known, from public records and the records of the TRC case, TRC report, that what was envisaged was that the TRC processes ran its course. And so those who did not apply, or should have applied, and those who were refused amnesty, they were supposed to be pursued by the NPA.
I confirm that.
Now, have you any comment about, there's a lot of people who don't apply for amnesty, and this is what President Mbeki highlighted in his speech in 2003. There's a huge group of people who don't apply for amnesty. Are you able to comment if any of those who didn't apply were pursued, prosecution and investigation-wise?
I'm unable to properly answer that because I only dealt with these matters, and the rest I know there were dockets all over the DPP provincial offices. I think they counted well over 400. As to whether they finally prosecuted them, I cannot answer.
You deal with the conclusion in paragraph 96.
Correct.
Just read that into record.
In conclusion, Chairperson, I deny emphatically that I, as Ledwaba or the DSO, stopped or interfered with the investigation or prosecution of TRC cases. We offered support from the beginning in April, May. We engaged with them. Ultimately, we gave them the tools in form of declarations in 2004 for them to proceed.
Is there anything else that I would not have asked you that you wish to bring to the attention of the Commission to assist it with this mandate?
If I remember, Mr. Chairperson, there was one item which is not here, and I thought I should respond to it. When Mr. Nuka was testified in these proceedings and was cross-examined, the memo of Mr. Lisk and the remarks of Mr. Kalata to say the NPA or the DSO stopped the investigation and this stance was remarkable. Mr. Nuka seems to have accepted that as a correct situation, and he said, being shown this memorandum, he was not aware of the decision Ledwaba took. So seemingly he agreed that that memo entailed that the DSO stop the investigation, which is this memo. And I'm saying he was also, without reading the memo, not strictly correct. The memo does not in any way says the DSO stopped. He then says, to show that he didn't agree with this wrong decision, he set aside, he reviewed and set aside, if I can use that word, that policy, and approved those requests. Strictly speaking, he never reviewed the memo of July. Projects were then handed to him in December and February in terms of the correct legislation, and he approved them, only instructing them. The two are not related.
And so the point you want to emphasize is that he exercised his powers in terms of the applicable section in the legislation.
Correct.
28(1)(b).
Without reviewing my so-called earlier decision, which is not even in existence.
And as you had said, you had advised the PCLU people to use the correct legislation.
At least 3 times.
At least 3 times.
Which they finally did in December, and Mr. Nuka complied and approved them in February 2004, 24 and 26 February 2004.
And he was not reviewing any decision that you had taken?
No, I mean the memos are here that he signed. There is no mention of an earlier decision being reviewed under 1745 and 1746. It is straightforward. He is being given 6 matters to consider. He feels happy that they can be dealt under 28(1)(b), and he directs that they be dealt with accordingly, and we authorize the projects.
Chair, those are the questions for the witness.
Thank you, Mr. Nalane. Let me start with Ms. Ntloko. Any questions for clarification?
Thank you, Chair. We have a few questions. It's afternoon, Mr. Ledwaba.
Afternoon, Council.
Just a few clarification questions. I, in this proceedings, act for the National Prosecuting Authority. To just put your mind at ease, if that helps at all.
Don't swallow your words, Sisi.
I am trying to find the document where I put these, so I did not want that on the record, Judge. If we can just go to your statement at paragraph 92. There you indicate that the DSO authorized the investigation of 6 TRC matters as directed by the NDPP in 2004. Can you then confirm for us if the DSO did in fact conduct those investigations?
The overall management of the project still remained with Mr. Ackerman and McAdam. And DSO investigators, Mr. Lisk is here, from his unit were then assigned and designated on each of those 4. As to whether Mr. McAdam and Ackerman did follow up and did the investigation was no longer my baby, and I don't know.
Thank you. We will follow up with them. And then in paragraph 93, you state that in your view, this PCLU had no impediments from pursuing any investigation utilizing section 28(1)(b) processes by applying to the NDPP.
I confirm that.
Can you just, on that very, on those very paragraphs, and this you say the same thing in fact with paragraph 61, can you explain the distinction between Section 21A and Section 21B as you understood it at the time and how they operate?
I think in paragraph paragraph 36 and 37, we show that firstly under 28(1)A, the head of operation or head of operation is limited to specified offenses under that section. There he has a discretion to authorize or decline a project. And if we go back, you define what is specified offense in paragraph 36, which is defined under 7A as relating to serious, high-profile or complex corruption cases, high-profile or complex commercial cases or financial crime, and the third one being high-profile and complex organized crime cases, and the last one being racketeering and poker, prevention of organized. So those four, once they are brought to the investigating director through the intake criteria, you can then authorize them or decline them as the head of operation, as DSO projects, automatically designating investigators to them. The DSO, in terms of investigators, did not operate like SAPS, South African Police. On each project, it's not like any DSO investigators can just come in and assist. There had to be a special designation in terms of the legislation to identify that under Project A, Mr. Nell and this, the head of Gauteng and this investigators identified, and this prosecutors will deal with this one. Otherwise, he would not or she would not have powers under the NPA Act. 28(1)B, it's read on page 1706, and I think we have read that. It says, if the national director refers a matter in relation to alleged commission of specified offense to the investigating director, the investigating director shall conduct an investigation or a PI as referred to in subsection 13 on the matter. So to my understanding and those that I worked with at the time, the mandate covers the four legs. However, the national director is given superpowers in terms of that subsection to go beyond the mandate of the DSO, but even then he must specify what type of offenses he is now forcing the DSO to do, because it says shall. And if we read his declaration under 1745 and 1746, he mentioned what type of specified offense. The Roman figure 1 under 1745, he says kidnapping, assault, and murder. So that is the specified offense he mentions. The second one, he says murder or attempted murder of Reverend Chikane. That is the difference. So without him authorizing or issuing a directive under 28(1)B, those matters that do not fall within the core mandate of the DSO would never have been authorized. Otherwise, the people could have challenged that authorization in court, and the whole authorization might have been declared unlawful and wasted DSO time.
And then just to deal with the advice that you indicate in various places in your affidavit between May and November 2003 that you gave to Ackerman SC and McAdam, did your position on this advice ever change?
Never. We know finally it was accepted and the 6 matters were done according to that advice.
And then in your affidavit, you indicate that Ackerman SC and McAdam had a difficulty accepting that you are now their senior, was this a recurring occurrence or was it a once-off issue in relation to this particular aspect where you had informed them to make an application to the NDPP?
I think in terms of relationship, once I was promoted to this level, most of my then senior were not happy. And there was this friction, and when they had to deal directly with me now as their boss, it became apparent that there was this friction, that they were unable to comprehend or accept that now I'm their boss, and I'm even giving them advice which they thought it was incorrect.
And then just on that advice, was there ever a time where you thought that maybe they might have misinterpreted your advice or they didn't understand what the advice that you were giving?
No, even in the last meeting in November, I told them that I'm now tired. I cannot explain the same thing to you people. And I think we left on not such good terms then.
And then one last question. In paragraph 83 of your affidavit, you indicate it is inexplicable and confounding to me why the PCLU only utilized the section 28(1)B process only in respect of 6 matters, leaving out the rest of possibly ripe matters that could have been similarly authorized by the NDPP. Sorry to say that's the last question. In fact, there's 2 questions under that. What other possibly ripe matters were there in your understanding at the time, apart from the 6?
Firstly, if you look at the annexure MGL 1 on page 1723, they inherited at least 14 matters, and they identified there. The first one, I don't have to read them if the commission so says, but all the 14 include the 6 that they ultimately applied. All these 6 have been investigated, already being investigated in the DSO by Mr. McAdam, Mr. Lisk, and them. And they inherited them. At least they had 14 ripe matters, but I know they had 44 matters at their disposal on their own audit then. But they picked only the 6, and nobody can explain why. That's all I'm saying in that paragraph.
And then truly the last question. When you refer to the PCLU, are you referring to the unit as a whole, or are you referring, this is in paragraph 83 and other paragraphs where you say, I gave advice to the PCLU. I do not understand why the PCLU did not do a particular thing. Are you referring to the unit, or are you referring to specific individuals in the unit?
I think that I'm referring to the individuals that I interacted with, mainly being Mr. McAdam, or Advocate McAdam, Advocate Ackerman, and I think in 2008, 2003, there were only 3 or 4 in that unit. Advocate Trc Prosecutions joined them later. Advocate Sean Abrams joined them later, and I think 1 or 2, but they were not really role players in my interaction with the PCLU, only the 2. Dr. Trc Prosecutions, I think I engaged him only once, but not in relation to the 3 encounters I'm referring to.
Thank you. That would be all our questions.
Thank you, Ms. Ntloko. Ms. Ntambeleni.
Thank you, Chair. I have no clarification questions.
Thank you.
for this witness.
Ms. Moroka.
No questions for clarification, Chair.
Ms. Ranto.
You're talking to yourself.
My sincere apologies, Commissioner. This is really never intentional. There's always an issue with my mic every time I have to address the commissioners. It's not the afternoon. Good afternoon, Mr. Ledwaba.
Good afternoon, Councillor Ranto.
My questions are directed at your testimony insofar as the SAPS is concerned. I represent the South African Police Service.
Ms. Ranto,
Ms. Ranto,
it's
we
very
can't hear
hard
you.
to hear you.
Yes, please repeat yourself.
Okay. I simply wanted to inform Mr. Ledwaba that my questions would be in relation to the SAPS, which is the client I represent in this commission, Mr. Ledwaba. Firstly, in your testimony, you spoke of the TEF that you found taking place when you took over as the head of the DSO. Remember that between the SAPS and
Turf war.
whatever they called, there were issues. Thank you, Commissioner Kromo. And your evidence before the commission is that at some point you had to come up with a service level agreement,
Correct.
and that was intended to regulate or define or demarcate exactly as to that those cases that would be investigated by the SAPS and those that would be investigated by the DSO, right?
As per their respective mandates, correct.
And then just for my own understanding, the service level agreement, the SLA, only related to those cases that were not TRC cases, isn't it? They
Yeah.
were, in other words, it was unrelated to that.
TRC were not mentioned or included in those discussions at that time or included in the SLAs that we entered into.
And from your knowledge and your engagement as part of the NPA management as you testified, was there ever any SLA in that regard insofar as that which the SAPS had to do and the PCLU insofar as the TRC cases were concerned?
I really stayed far away from the TRCU because of our relationship, and I do not want to even comment on what they did.
But at some point, you did investigate the TRC-related matters. Remember that the ones that were directed in terms of Section 28(1)(b).
Only
by
in
the
2004 and the 6
Later,
matters,
of course,
correct.
yes.
Correct.
Yes, but I wanted to understand if you were aware if there was any SLA that was in existence.
In my time until I left, no, I am not aware.
You also testified that insofar as you remember or you knew, all TRC cases were investigated, were at all times investigated by the SAPS. Remember your testimony in that regard?
No, I'm not saying I was aware. I'm saying the understanding was that TRC, from the speech of Mr. Mbeki, that the prosecution will be NPA and investigation will be SAPS. That is what I'm saying was my understanding and the NPA understanding.
It was your understanding.
Correct.
If maybe so, I need clarity in relation to the memo that you addressed to Advocate Lisk. I think it's MGL 5 or 2?
2.
It's 2.
MGL 2.
Yes. Paragraph 1
Correct.
of the memo. Specifically where you say the need arose that the mandate of the DSO be redefined. If I may, perhaps, my sincere apologies, Commissioner, I just want to go specifically to MGL 2. Thank you, Commissioners. If I may assist Mr. Ledwaba, it's a memorandum dated 15th July 2003, and specifically, yes, it spoke to SNPU. I think that's where my confusion was coming from. Paragraph 1 says, due to the recent creation of the PCLU, it has become necessary to redefine the mandate and operations of the SNPU as follows. Well, Roman figure 1 specifically, you deal with the TRC cases. And
I
you
confirm.
Yes, and you specifically state that you have decided that the SAPS must take over investigations of all such cases. You remember that?
I'm reading it, yes, I remember.
Now, I'm trying to understand if it is so in your evidence that all TRC cases have always been investigated by the SAPS. Why would there be a need for such a decision in a way? If it was so that, from what you knew, all TRC investigations were conducted by the SAPS.
When I took over as the head of operations, there were these 14 cases that came along SNPU from Mr. Nuka's office and were located in the DSO without being, strictly speaking, within the mandate. I think on the 14th of May, Mr. Nuka decides that all TRC cases now, whether they are in the DSO or in the provincial office, fall within the PCLU. The PCLU has an investigative and prosecutorial mandate, but no investigators. I'm saying the understanding even then was that the constitutional mandate of normal murder cases, robbery and kidnapping will be SAPS. And I think Mr. Nuka, when he testified that there was no need for him to approach the president, because it was also his understanding that SAPS will do the investigation. So it's not only mine, but when I wrote this paragraph was just to formally record for purpose of records to Mr. Lisk and SNPU that officially now DSO is not longer going to be involved. We're transferring to the TRC cases to PCLU, which will then run with SAPS like all other PCLU cases. That's all that it entails to.
Now, what is then stated in paragraph 45 of your affidavit, insofar as the decision to refer to SAPS, our investigations for the SAPS. Paragraph 45 there, where you say it was, however, the understanding is discussed in the NPA co-management meetings where Dr. Ramaite was in attendance that investigation of the PCLU case would be done by the SAPS.
Correct.
And that was preceded by your statement that PCLU was clothed with both investigative and prosecutorial powers. Remember that?
Correct. That is, sorry, what the proclamation says. They are now created. Only prosecutors are assigned to the PCLU and no investigators.
And that's what I'm trying to understand, if they were both clothed with powers to investigate and prosecute. And I'm trying to juxtapose that with what you said earlier, that the SAPS were the only ones that were investigating the TRC cases. And I'm trying to understand PCLU, investigation of TRC, where did it start, where did it stop? And SAPS, where did it start, where did it stop?
To the best of my understanding, the PCLU was formed or proclaimed on 23 March 2003 with specific identified mandate, and we list them in 43. In May, Mr. Nuka, in conjunction with NPA, decided to elevate TRC cases and identify them as priority crimes so that he can then take them and put them within the proclamation of the PCLU. And from that day, they were all proclaimed as PCLU cases, who, according to the proclamation, they have both investigative and prosecutorial powers. But the reality is they don't have investigators appointed or even seconded to them. So there was a lacuna somewhere in terms of that placing of investigators in that legislation there, without identifying or appointing specific investigators.
Okay, but you were aware of TRC cases being investigated by SAPS, as you said?
Correct.
And do you know who was overseeing the investigation?
I do not.
Was it someone from SAPS?
Together with the DPPs, all the dockets that are managed by the DPPs were investigated by SAPS. As to whether they were all allocated under one division, I would not know.
But now, investigative powers of the PCLU, I'm just a little bit confused that the PCLU had powers to investigate, and I'm trying to understand what investigations would that be, or what those powers, what did they entail?
In 43, we quoted what that proclamation says. It's not my making. The proclamation itself says they were mandated to, and it's highlighted, to direct investigations and prosecution. That's all it says. So prosecutors in the NPA deal with prosecutors, and SAPS deal with investigation. That was the norm and still the norm.
And the PCLU at that time, in particular Advocate McAdam, what was his role during these investigations then?
You must cut off his position from May, when he was transferred from DSO to PCLU. So when he was in the DSO prior to this policy, he worked with TRC matters under the cloth of DSO with DSO investigators. Once the policy kicked in, cases were transferred. He doesn't have powers under the NPA Act, but he can only work in terms of the proclamation where TRC matters now duly fall.
And he reported to you prior to that, prior to May 2003, isn't it?
Correct. At the time when he was in the SNPU, DSO, him, Mr. Lisk and Mr. Tongwane reported to me. Then he took a decision that he's transferring from the DSO after talking to Mr. Nulga, and moved to the new big unit of the PCLU. And from then on, I think he reported to Ackerman, Advocate Ackerman, who reported to Dr. Ramaita.
And you cannot tell how he collaborated with the SAPS insofar as the investigations and the prosecution is concerned?
I cannot.
Okay. In your evidence, still in paragraphs from 43 up to, say, paragraph 45, where you spoke of the understanding of the EXCO insofar as the SAPS was concerned. Specifically in paragraph 44 of your affidavit, you do indicate that, or rather you stated that there was a challenge that no specific investigators were employed or assigned to the PCLU from its inception. Remember that?
That is the lacuna I'm referring to.
And then you go to 45, that then your understanding, as discussed in the NPA EXCO management meeting where Dr. Ramaita was present, the understanding was that such cases or PCLU cases would be done by the SAPS.
I confirm this.
So that's PCLU cases, but they're done by the SAPS. But be it as it may, my question then in relation to that is that from your evidence, it would appear as though the issue of saying that, or the EXCO management understanding or decision was intended to cure the lack of capacitation towards the PCLU, isn't it? In other words, the PCLU was established in terms of the proclamation. Unfortunately, there were no investigators.
Are you putting it to him, or do you
I'm
want
repeating what
clarification?
he said, Commissioner Khamu. It's simply what the witness said in paragraph 44.
What do you want clarified?
What I'm trying to get as clarified, Commissioner Khamu, is now, insofar as the PCLU was not properly capacitated, or was not at all, because the witness says from its inception, there were no investigators assigned to that. And my question now, for clarity, because the witness then proceeds to inform the commission that in the NPA EXCO meeting, a decision, or the understanding, whether it was a decision or understanding, but some sort of a decision or an understanding became that the SAPS would then have to deal with the PCLU cases. So my question, I'm saying based on his evidence, I'm trying to find out from the witness as to that whole thing, or paragraph 45, or the EXCO decision that SAPS would take over, was intended to cure that which you pointed out in paragraph 44, which is the fact that there were no investigators assigned. In other words, during the meeting, from the evidence, I'm trying to check with the witness if my understanding is correct, because if I follow his testimony or his evidence, is that from inception, PCLU was never assigned any investigators. Then the witness says, at some point, EXCO management then said, such investigation would be done by the SAPS. And my question was, this was done to cure that which was a problem created by lack of assignment of investigators to the PCLU.
Yes. Mr. Ledoa, you follow that?
I do follow, Commissioner.
Yes. Deal with it.
My answer is, I'm saying it is the NPA EXCO management's position or understanding. Simply by reading, the core mandate of prosecutors is to prosecute, the core mandate of police SAPS is to investigate. And that is the idea how the TRC cases were to be handled, and that is probably why Mr. Nmuka decided to move them out of the DSO who were investigating these cases and allocate them to a new unit that will focus on them, who were already dealing with matters within the PCLU context with SAPS. It follows that SAPS will then be on their constitutional mandate to carry the rest of the investigation in support of PCLU. It might have been not identified in the proclamation, but it was common cause. Prosecutors prosecute NPA, SAPS investigate dead dockets.
Okay. Perhaps just a follow-up on what Mr. Ledoa said. A common understanding from the proclamation. The proclamation was clear that the NPA would be the one to carry out that responsibility. I think it's common cause, as you also said. But then the decision of the EXCO, NPA EXCO management, I'm trying to understand, because it would appear as though there was a common understanding among the NPA officials that the SAPS would have to carry or execute that task of investigation. But the question now becomes, was this communicated to the SAPS? So that, in other words, I'm trying to understand, this understanding, was it common between NPA and SAPS? Or was it ever communicated, or was there any consultation of some sort? Just to understand if you were on the same page with the SAPS insofar as that is concerned.
To my best understanding, it was common cause. PCLU is mandated first in the proclamation on those identified cases of theirs, before we pack in TRC. And we have shown in those few paragraphs that those cases that they dealt, terrorism, international crimes, can't remember the rest, nuclear stuff, were investigated by SAPS and prosecuted by PCLU. So it was a common understanding. The fact that TRC cases now come to PCLU cannot change that situation. SAPS must just continue with them as they've been doing with PCLU. That is why I'm saying it is a common understanding.
But my question was, that common understanding prevailed within the NPA only? Or was that the common understanding with the SAPS as well?
I can't answer that.
Okay.
Maybe.
And then also you spoke of request made by Advocate McAdam for the DSO to appoint investigators. I think Ms. Ntloko referred to a number of paragraphs, but there's also one specifically in paragraph 61 of your affidavit. And I just want to clarify if my understanding is correct that requests or applications that were made by PCLU for you to appoint investigators within the DSO was also intended to cure the issue of lack of appointments of investigators attached to the PCLU from inception, as you stated earlier. So in other words, these requests were also intended to deal with, I don't want to say it was a failure by the NPA to capacitate PCLU, but in your statement you said from inception no investigators were ever assigned to that, and I'm trying to understand your understanding if the request by Advocate McAdam was also intended to cure or deal with that issue or the problem that was created by a lack of appointment of investigators to the PCLU.
I don't want to speculate on Mr. McAdam's part, Commissioner.
Well, maybe then to move away from Mr. McAdam, in what you said to earlier to Ms. Ntloko, or in response to Ms. Ntloko's questions, was an issue of you urging them or encouraging them to make use of Section 28(1)(b). Remember, in other words, you would say, I would assist subject to you getting proper directive issued by the NDPP.
That was the
in
law.
terms-
That was the law.
Well, it may well be that I'm trying to understand that also was intended to assist with that lack of capacity that you said was never, has always been a problem from inception. In other words, it was also one of the method that from your side you were using to say, because there were no investigators from inception assigned to PCLU, if you want me to assist, then let there be a proper directive issued in terms of Section 28(1)(b). Is that my understanding that that's what was intended with you requesting that there must be a directive?
Yes or no, Mr. Litwaba?
No.
And then you also spoke of the decision, the same decision that is recorded in the MGL2, and I simply need clarity in terms of what you stated, that I have decided, and I wanted to understand in terms of what you decided. Where did you derive such powers to decide that those be transferred to the SAPS? And perhaps if I have to qualify why I'm asking that question, I'm asking it in light of the directives that were issued prior to that by the NDPP, Advocate Nguka. I think it must have been the one dated 8th December, but I think he signed on the 24th of February. And then there was another one that was on the 26th of February, 2004, where he directed that certain cases be investigated by the DSO. Now, going back to what I was asking you is that when you then came with the memo MGL2 to say, I have decided, and I'm trying to understand in terms of what powers did you decide that those cases would have to be referred to the SAPS?
If I heard correctly, Chairperson, Council is saying Mr. Nguka's directive were issued prior to this memo. That is definitely not correct. The memo is in July 2003, and Mr. Nguka comes later in 2004. The power that, if I may answer a direct question, is I'm saying in April, May of 2003, Mr. Nguka and EXCO, it came from him and EXCO, take a decision which becomes a policy that TRC cases, wherever they are located, must now fall under PCLU. All I'm simply doing is, even though I use the word I, but it was in my official capacity, I'm implementing that policy, transferring in line with that policy TRC cases from DSO to PCLU. Later in 2004, Mr. Nguka did approve under 28(1)(b).
In a way, I think, yes, I may have missed the dates. I think I did the other way around, but the Galata group is one of their complaints that pursuant to that decision that they do refer to you saying that cases be referred to the SAPS, but nonetheless, SAPS refused to take over in a way. And that is why my question was intended to find out as to whether you had the relevant powers to instruct as such, but I think you have since addressed my concern in relation to what was subsequently developed. And then, sorry, Commissioners, I'm almost on just one last more question. paragraph 90 of your affidavit, Mr. Ledwaba. Nine zero. That's where you inform the commission, or you refer to the Galata affidavit, where it stated that the DSO persisted in its refusal to appoint investigators, as did the SAPS. Now, what seems to be at play, and I'm trying to get your understanding, if it's also your understanding, at paragraph 90, or in paragraph 90, there are two issues at play according to the Galata group. One being SAPS refusal to investigate, and secondly, the DSO's refusal to appoint investigators. Would you agree? I don't know. I think is that your understanding too? In terms of what you refer to them, there are two issues at play there. In terms of what the Galatas are saying, they say DSO persisted in his refusal to appoint investigators, as did the SAPS.
I gather that is their view, yes.
Now, from your evidence, I'm trying to get clarity if your because I'm also now trying to understand from what you testified in response to what the Galata group are saying. So in your evidence, I understand to say there are two issues that were at play. You did speak to the letter of Commissioner De Beer, although you didn't really get into detail, but you would recall referring to the letter of Commissioner De Beer, who said the SAPS would not be inclined to take over or investigate unless the President clarified the role. Do you remember that memo or the letter of General De Beer?
I do.
Yes. So I'm trying to understand that from your evidence that there are two issues at play here in response to what the Galatas are doing. There's an issue of the letter or reluctance or perceived reluctance on the part of SAPS, subject to, of course, clarification, because the letter of General De Beer makes it clear that there's no unwillingness, but subject to the President clarifying that it must be them, not the NPA. And then secondly, yours specifically, also from your evidence, I'm trying to understand if I'm correct that the DSO's reluctance to act was not necessarily an issue of any influence, but rather the issue of you persisting that you would assist, provided that there was a proper directive issued in terms of Section 28(1)(b) of the NPA Act.
Correct. We never refused to appoint investigators if it was done according to the right procedure, and which was then later done.
Meaning whether it's SAPS, and I know that I'm mindful of the fact that you were not the author of General De Beer's, Commissioner De Beer's letter, but you were aware of it, that the two issues from your evidence were not related to any political interference.
I became aware of Mr. De Beer's letter through this commission.
Yes, what I'm saying is that either it's a lack of assistance or perceived lack of willingness to assist, either by the SAPS or the DSO, had nothing to do with politics, but it was informed by SAPS talking to the proclamation that they said, it said NPA, and then also DSO saying, nope, we can do it, but only insofar as the directive was properly issued by the NDPP, page 20 of Section 28(1)(b).
It will be fair, Commissioner, to confine myself to DSO. There I can say yes.
I accept that, yes.
Ms. Rantu, I was made to understand that was your last question.
Well, under that pressure, Chairperson, I suppose, I tried to run through some of the things. I thought Ms. Mhloko dealt with them. That's why I was avoiding to deal with them. But be it as may, I see that the Chairperson is really pushing me to say that I'm done. But under those circumstances, I will end it there. Thank you so much, Commissioner.
Thank you, Ms. Ranto. I think this will be an appropriate time to adjourn for lunch and reconvene at 2:05.
relating to serious, high-profile or complex corruption, commercial or financial crimes, and organized crime. This is the core mandate as it was defined for the DSO, then Chairperson and Commissioners. Roman figure 1 also matters referred to the investigating director by the National Director in terms of Section 28(1)(b), or referred to the Roman figure 2 referred to the investigating director in terms of Section 28(1)(a) or 28(13).
I know you come to this later on, you explain it, but just to explain it further. So you understand 1A says this deals with the investigating director.
Correct.
He may investigate matters relating to serious, high-profile, complex corruption or commercial financial crimes and organized crimes. That's the function of the investigating director.
And to our understanding then, this was the core mandate of the DSO and nothing else.
And then Roman figure 1, which you just read, the national director may also refer matters.
Correct. There was a provision in the NPA Act under 28(1)(b), which gave the national director overriding powers on type of cases. He would direct the special director or the investigative director to investigate, even though they did not strictly fall within the mandate of the DSO.
Okay. You may proceed.
And the Roman figure, the other in page 1706, relate to the legislative parameters of the mandate, being the prevention of combating of corrupting activities of Act 204, 12 of 2004, as well as the Prevention of Organized Crime Act 121 of 1998.
And what were the additional related statutory offences or categories of statutory offences?
These are the two that I mentioned under B, Roman figure 1, and B, Roman figure 2.
Was it limited to just those two?
At the time, correct.
At that time?
Correct.
You may proceed. 37.
As the head of the operation or investigating director, I was the only person who could authorize an investigation in the whole country in terms of Section 28(1)(a) and 28(13) of the NPA Act.
Just explain that.
I think if we read first 28(1)(a) as well as 20(a) in paragraph 13, then I can explain.
Proceed.
The subsections are then referred to in full under paragraph 38, Chairperson. The first one being 28(1)(a), which reads as follows: if the investigative director has reason to suspect that